Greetings and welcome to some basic preliminary reflections on just declared Supreme Court judgment on the ALIGARH Muslim University status, by which, by a 4-3 majority judgment, the Apex Court has restored the minority status to ALIGARH Muslim University, which was abrogated by a 1967 Supreme Court judgment, now famously known as the Aziz Pasha versus the Union of India judgment. I don't want to take you through all the twists and turns of the legal battles, the legislative interventions, etc. From the time the institution had its inception way back in 1875, in the month of May, if I remember right, it was the 24th of May, 1875, coinciding with the birthday of Queen Victoria. And perhaps in some sense or to a certain extent that explains the rather peculiar name given to this college at that time. It was not a university, it was a college. It was called the Mohammedan Anglo-Oriental College. The Mohammedan Anglo-Oriental College started under the auspices of the ALIGARH movement, spearheaded by Sir Syed Muhammad Khan, Sir Syed Muhammad Khan. Now, it may be worthwhile to mention here that the purpose of this institution or the purpose of this educational enterprise was to provide Western-style, modern, progressive, liberal education to Muslim students. And Sir Syed came up against very stiff opposition by the Orthodox mullah, the Muslim priestly class, who was stiffly opposed to the Muslim children being exposed to modern education. By the way, I also need to mention that as compared to the Christian community, Islam is much less plagued by the hegemony of the priestly class. Even so, the pro-orthodox, anti-progress established elements are deeply entrenched in the sinews and nerves of the Muslim community, and they have always resisted all well-meaning efforts to open up opportunities of the modern age, the modern society to the members of that community, which to a large extent accounts for the continuing backwardness, educational as well as related backwardness of the Muslim community. And I'm glad to note and report that this is now changing. A tremendous, unprecedented awareness is now spreading through the length and breadth of the Muslim community in India, and particularly in Kashmir, that education is really the key to the future, and the Muslim youth are grabbing opportunities available to them to be educated as per the modern liberal education paradigm. And when I was the principal of St. Stephen's College, I made it a particular point of emphasis to open up the opportunities in St. Stephen's College to the Muslim youth, particularly the youth from Kashmir. And I made a small reservation for candidates of this category, which of course attracted a lot of adverse attention from the people who matter. But that's as an aside. Now, the matter has been pending with the Supreme Court of India almost since 1987. And mercifully, thankfully, before his retirement, the retiring Chief Justice of India, Dr. D.Y. Chandrachud, decided to activate the matter, constituting a 7-judges bench, which has just delivered its verdict. And I was contacted yesterday by two newspapers, Hindustan Times and Indian Express, to write articles for them. I refused to write for them, and for the simple reason that I now find it morally repugnant to be associated with the media in this country. That's one of the reasons why I started this YouTube channel, so that I can relate directly to my brothers and sisters without having to be hamstrung by the commitment to vested interests of the mainline print as well as digital media. Now, what do I have to say on this matter? Now, I'm going to uh, do this in two parts. In the first part, in the first video, I will examine the salient features of the dissenting note or dissenting verdict prepared by three judges, um, Justice Suryakant, Justice Dipankar Datta, and Justice Satish Sharma. As far as the majority judgment is concerned, maybe I'll do it on a later occasion. But the salient features of their objection, which is what we need to understand. Then in the second unit, I'll give some general reflections on minority educational rights. I'll look at the pros and cons because I think we must be objective in the standpoint that we adopt. We must abjure, we must renounce all partisan, parochial, and communal attitudes because these things corrupt us, and there is no reason why we should allow ourselves to be corrupted just to protect and promote the corruption and vested interests of a very tiny nucleus of people within minority communities who have hijacked this very precious trust that the country as a whole has reposed in the religious minorities. All of us know that the nationally recognized religious minorities are just five, though after the 2002 Supreme Court judgment, TMFI Foundation versus the state of Karnataka, the definition of minority community has changed. Now, minority status is decided not based on the national spread, but as per the demographic picture within each state. That itself was a controversial judgment. It was decided by a majority judgment. And Justice Rumapal, with whom I had very cordial relationships when I was in Delhi, and even now we keep in correspondence. She was one of the dissenting judges, and hers was perhaps the most cogently argument stand in that verdict. But that again is as an aside. Now let's examine what the dissenting judges have said. First of all, they say that the 1967 Ashish Basha versus Union of India ratio means the rationality, the reasoning that the judges use, ratio, was correct. And what was the ratio? The ratio was that the ALIGARH, the Mohammedan, pardon me, the Mohammedan Anglo-Oriental College, which was started in 1875 as a purely Muslim educational enterprise, underwent a substantial change in identity by 1920 when, as per an act passed by the Imperial Parliament, the Indian Parliament did not exist at that time because India got independence only in 1947. So in 1920, if a law is passed, it is passed under the Imperial Parliament. So as per the the law passed by the Imperial Parliament, the Mohammedan Anglo-Oriental College was upgraded to the status of a university because as per the law, a university can be started only under an act of either the state legislature or the parliament. If it's a state university, then concerned state legislature has to pass an act. If it's a central university, the parliament passes the act. So, the upgrading of the Mohammedan Anglo-Oriental College to the status of the ALIGARH Muslim University was accomplished under the aegis of an Act of Parliament passed by the Imperial Parliament in 1920. And therefore, the ALIGARH Muslim University is a completely different legal entity as compared to the Mohammedan Anglo-Oriental College started in 1875. Though the parent, preceding institution, the antecedent institution was definitely a minority institution. The reworking, the second avatar of the institution of the ALIGARH Muslim University cannot under any consideration be considered a minority Muslim institution because it is not instituted, established by the Muslim community. It's been established under an act of the imperial parliament, and therefore it has lost it is not entitled to its minority status. That was the ratio of the 1967 Aziz Basha versus Union of India judgment, which was the law, the settled law in this field till yesterday, when the Supreme Court gave a dissenting order revoking the previous one. That was a 5 judges bench. Now, in this case, it's a 7 judges bench, which has therefore the authority to overturn the judgment given by a 5 judges bench. So, there's a background. Now, the dissenting judges say that insofar as the ALIGARH Muslim University has been established under an act of parliament, the Muslim community has completely lost control of the institution that was established in 1875 under the title that I have repeatedly mentioned. Hereafter, I will not mention that name. So, secondly, because it was so constituted, argues the 3 dissenting judges, the control of the institution has passed on from the hands of the Muslim community to the non-Muslim governing elements. Now, when an act of parliament under which a university is established is passed, it will stipulate its governance structure. Now, the Muslim community did not have at that time the ability to anticipate what would happen after 1947, after 1951, and then the subsequent changes that would happen. In good faith, it agreed to the upgrading of the Mohammedan Anglo-Oriental College to a university, and therefore all these complications have arisen. Had they anticipated, perhaps they would have bargained with the government, which they were in a very strong position to do, to build in sufficient protective riders to ensure that the kind of problem that was precipitated in 1967 did not materialize. But who can anticipate what's all going to happen in the march of time? Therefore, such protective measures were not incorporated. So, the 3 judges argue that for an institution to remain a minority institution, its control has to be almost entirely with the particular community that claims ownership of it, and it must be established and maintained for the benefit of its members, which is a highly questionable assumption, I have to say, because there are statements, there are judgments prior to this which says that a minority institution can be run with a sprinkling of the presence of the candidates or students from that community. In other words, a minority institution can be established and run largely for the benefit of non-members of the same community or members of other communities, because minority institutions have to be established in various parts of the country, and the minority presence is not uniform. For example, if you think of a Christian college situated in a state like Himachal Pradesh or Haryana or Rajasthan or what have you, where the Christian presence is less than 0.5%, it is quite unlikely that a college can fill that institution up to 50% with candidates from the Christian community. For example, even St. Stephen's College is situated in Delhi, where the Christian presence is about 0.8% of the total population. It was difficult to find good enough students to fill all the seats, and therefore Christian reservation was never implemented in St. Stephen's College until it was implemented in 2007 by me, for which I had to pay dearly, which is a story that I have recounted in my memoir titled On a Stormy Course. The title itself is suggestive. If you have any interest, please read that book. You can gather very interesting and instructive details from it. so that you know how emotive and how hotly contested the particular issue is. Constraints of time do not allow me to take you to the details in that book, nor is it necessary. So, the argument of the dissenting judges is that when the ALIGARH Muslim University was created out of the Muhammadan college, the community, the Muslim community, has lost control of the institution completely, nor is it now run largely for the benefit of the Muslim students or students from the same community. This is by and large the argument used. Now, there are other points made. Let me not go into it. A third issue, of course, is the fact that if the antecedent institution was established and run largely out of, or almost entirely out of, the funds raised by the community itself, after its upgradation to the status of a university in 1920, the resultant AMU has been maintained with government funds, grant in aid. Every university gets grant in aid. In fact, every minority educational institution other than self-financing institutions or institutions that opt to be self-financing ones get grant in aid from the college, from the government, state government or the central government, as the case may be. And there is a compelling reason for it. The reason is the government, by its rules, regulate the extent of tuition fees that can be realized from students. For example, even today, a student studying in St. Stephen's College pays a monthly tuition of 50 rupees. Tuition fee of 50 rupees. Can you imagine? You can't buy an ice cream. You can buy half, can't buy half an ice cream for 50 rupees. But that's a tuition fee that a student pays per month. So obviously, an institution cannot be run out of the finances generated by collecting tuition fees or even related fees. So, as per the structure of governance, as per the rubrics of law, it's impossible to run an education institution other than self-financing institution where the fees can be astronomical, which again is regulated, but it's much, much higher. For example, where a student may be paying 50 rupees per month as tuition fee, a corresponding student in a self-financing institution may be paying maybe 3,000 rupees, 5,000 rupees. So that's the difference. All right. So now you by law compel a minority institution to accept grant in aid and then use that argument to take away minority rights from that institution, which is unjust. And therefore, there is a very clear judgment of the Supreme Court that providing grant in aid is no excuse or no valid ground for depriving a minority educational institution of its minority status. That's been the settled law of this land, and the majority judgment in this case also has reiterated it. Whereas the dissenting judges seem to think otherwise. Now, I think the dissenting judges entertain a very serious misconception. Let me quote what they have said as it is quoted by Times of India. It says, to assume that the minorities of the country require some safe haven for attaining education and knowledge is wholly incorrect. Now, this is what the three dissenting judges, whose names I have already mentioned, they are Justice Suryakant, Justice Dipankar Datta, and Justice Satish Sharma. This is their understanding. I have to say that this understanding is laughable. It is utterly laughable because it shows, I'm sorry to say, a gross misunderstanding or a lamentable inability to understand the history, the whole logic, the vision, the democratic vision, a pluralistic democratic vision which underlies the inspired structure and substance of the Constitution of India. Now, Christians are also by and large unaware of it. Let me spend 3-4 minutes on this because it's important that we attain clarity on this. Because even in the way we as Christians use minority rights, there is a terrible misconception underlying everything that we do. Therefore, it's important that we understand it. When the frame of the Constitution came up to this point of giving or conferring special educational rights on religious minorities, 5 of them, 5 communities, they were doing something very exceptional because it is something that contravenes the principle of equality, which is enshrined in Articles 15 and 14, both right to equality and the right to be protected against discrimination. So, carving out a space for minority educational rights is actually creating a space for unequal treatment or inequality, if you like, seeming inequality within the architecture of unity, of equality. It's a very serious matter. So, it actually amounts to conferring a very special privilege. But this privilege, the conferring of the special privilege was justified by an important consideration, which is what the religious minorities in this country have chosen to ignore, about which we need to be very clear. The framers of the Indian Constitution were very clear that India is and must forever be a religiously, linguistically, culturally plural society. And this plurality of religion, culture, language, etc., is fundamental to the survival and health of Indian democracy. If plurality is destroyed, ironed out, and homogeneity is artificially and coercively imposed on India by destroying the distinctive identities of small groups or the minorities, the predominant of them being the Muslim community, a community that today is about 13 to 14% of India's population, Christians being 2.18% of India's population, Sikhs being 1.9% of India's population. The Parsis and the Buddhists are of really not much significance, especially the Parsis, who number only about 60,000 in this country. So you can understand. But the numerical inferiority is more than made up by their economic, cultural, intellectual development, which is another exciting story, and this is not the occasion for it to consider it. Now, when the framers of the Indian Constitution finally decided to write Article 30, Sub-Article 1 into the architecture of the Indian Constitution, they were really not showing some kind of favor or partisan loyalty to any of these communities. They were making an investment into the robustness and health of Indian democracy. I emphasize this because, as citizens also, members of these 5 religious minority communities, when they understand and resort to the provisions under Article 30, Sub-Article 1 of the Indian Constitution, which confers special educational rights on religious minorities and linguistic minorities, they have to do so with adequate mindfulness of respect for the secular democratic character of the Indian Constitution. Article 30 exists within the architecture of the Indian Constitution, and therefore it is dishonest and fraudulent to invoke and exercise Article 30 in a completely in a state completely unmindful of and indifferent to the integrity of the Indian Constitution, which envisages a socialist, secular, democratic republic. And I am sorry to say, as a person who has worked perhaps more than most others in this field over 30, 40 years, that the Christian community is particularly remiss, at fault, deficient, irresponsible, I would say culpable, in the way it has understood and exercised and continues to exercise educational rights, minority educational rights, which is the subject for my next video. And therefore, what the judges do not understand is that the purpose of creating Article 30, Sub-Article 1 in the Indian Constitution was not to provide a safe haven for the children of these 5 religious minorities or other linguistic minorities. It is a gross and embarrassingly wrong understanding of the meaning of Article 30. And I am shocked that 3 senior judges of the Supreme Court of India can publicly articulate such totally erroneous and lamentably bankrupt understanding of Article 30. This is where, unfortunately, propaganda, the political climate, which is flavored by a certain degree of communal flavoring, communal accent, interferes with the dispassionate understanding of what the law mandates. Now, on the one hand, now look at look at the contradiction of which they are unaware, and I'll close on that. On the one hand, the very same judges argue that ALIGARH Muslim University is not entitled to minority status because it is not now run for the benefit of the students from the Muslim community. That's their first argument. Now they say that it is indefensible that education institutions are run as safe havens for these students of the minority communities. And sad to say, they are not able to sense the glaring contradiction between the two points they make, which is extremely, extremely shocking. Now, I quite agree with them that the minority communities, when they lack a sense of national consciousness and a sense of responsibility to the country, their share of nation building, they can misconstrue the scope of the privileges conferred on them in this manner. That's quite possible, and unfortunately it is happening, and therefore I can understand why these 3 judges who wrote the dissenting note make a statement of this kind, that it is not justifiable that certain legal, sacrosanct legal provisions are made in order to create and protect safe havens. Just imagine safe havens. Look at the concept, educational safe havens. I am someone who is totally convinced that is not good for the children of religious minority communities to be educated and nurtured in religiously homogeneous learning environments. I'm totally, clearly convinced about it. It is necessary for the health and the learning stimulation of the environment prevailing in our institutions to have a fairly adequate representation of the children from other communities, at any rate as per the law of the land. It is not possible to admit more than 50% of students preferentially from a religiously minority community. Therefore, 50% presence of children from other communities is guaranteed. So this idea that minority institutions serve the rather indefensible purpose of creating and maintaining safe educational havens for children of minority communities, I think is very regrettable, to say the least. And I'm shocked. I'm shocked that such thoughts are entertained at the highest levels of legal wisdom in this country. Well, I don't want to prolong my argument any further. In the next video, I'll examine what has happened to these minority rights and what are the dangers in the way they are being understood and exercised today. And it's highly important that members of the religious communities, particularly the Christian community, become far more aware and concerned than they are at the moment. That in the next video, and I wish to conclude by thanking you for your patient listening. All the very best. Jai Hind.